Good evening, everyone. There's very few of you here. Let's see if we can't get to at least 20 people, then we can start. Then we can quickly start, then I'll let you go. This is going to be a very short discussion. Okay, let's talk. Hi everyone. I trust you well. Listen, let's talk about the EB versus ER judgment. This judgment made some changes. Was decided in the Constitutional Court. It made certain changes when it comes to the marriage out of community of property without accrual. Let's clarify. We know that there's a lot that's been said, and I've been saying I will say something. Let's just do it once, okay? So a recap of this video, maybe you'll find in the other YouTube platforms that I have. But let's talk about it. There's a judgment that changed the Divorce Act. So in the Divorce Act, we've got Section 7, subsection 3. Now, Section 7, subsection 3 was used by people who got married out of community of property without accrual before 1984. That section was saying that anybody who was married out of community of property without accrual before 1984, they can ask the court to do a redistribution of assets at the end of their marriage with their spouse. For example, if let's say a wife was not working, married to a husband out of community of property without accrual, the husband wealthy, now they were splitting up. The court said if you were married before 1984, you can ask the court to do what we call a redistribution. What does redistribution mean? It means that the court could give certain things to the one that was not working, right? i.e. maybe certain properties, or decide that that person should get, let's say, money because they were in an unfair position because they did not contribute to the marriage financially. The court said these people were contributing in other ways. These people were contributing in other ways, right? But now, because they had no money, they were left without nothing, as if they were not helping their partner build this wealth. So the court said, or rather the legislation was saying that the courts, where they deemed it necessary and where it would be just and equitable, then they could give that spouse who was not well off, who had probably nothing, something, so that they are not left with nothing at the end of the marriage. Now, before 1984, this is what I want you to understand, is that before 1984, we had two types of marriages in South Africa. We had a marriage in community of property. You know the in community of property. It means that what is mine is now yours. What is yours is now mine. Whether you had acquired it before we got married, now that we are married in community of property, we are sharing everything equally, right? Whatever interests you have, they are also mine. Whatever debts you have, they are also mine. We share now in everything, marriage and community of property. The second marriage that existed at that time, it was a marriage out of community of property without accrual. There was no accrual. So, which means that a person, once, or people, when they entered into a marriage and they had separate assets, they would also be entitled to live with those assets, because the other one needed to have their own assets, right? So, there was no other marriage besides these two. This is why when the legislator introduced the third marriage, which is the marriage out of community of property with accrual, it then gave those people that were married before the establishment of this section the ability to ask for a redistribution, because the ones that were now going to get married after 1984 were going to have a privilege. What privilege? They were going to have the ability to enter into a marriage out of community of property with accrual. So they were adding a third marriage. As you know, this type of marriage, the one that's with accrual, it says that you keep your things separately, but you guys must share equally in whatever growth each of you acquires. So if you are not working and your spouse during your marriage, you supporting and being there, etc., they make much more money in terms of this marriage, they should share with you on an equal level the things you guys have built during the marriage. So at least with this one, people will always have something at hand when the marriage comes to an end. But obviously this thing is only relevant when the marriage comes to an end. So that's why these ones who were married before 1984 had that provision made in the law that they could ask the court, because it was too late. They were already married. And at that time, there was no other option. They only had two types of marriages. Now, what is happening with this case? What happened? So in this case, there is someone who was married after 1984 in a marriage out of community of property without accrual. And they also wanted to ask for a redistribution. Now, this is a problem, because why? The section which talks about redistribution only applied to people married before 1984. Now here comes this one who had the privilege of choosing between three marriages, saying, now I also want to be afforded the right to ask for a redistribution. It's unfair that this right is only afforded to people who were married before 1984. It's unconstitutional, you know, and therefore it violates the right to equality that's encapsulated in the Constitution in Section 9. And the court, in a sense, also agreed that this whole thing of treating people differently because they were married before 1984 and not after 1984, they said it was unfair, as much as it came from the fact that they were protecting the interests of the ones who did not have the privilege of the third marriage. The court still said that, no. Those who are also married after 1984, they should be able to ask for a redistribution if they have chosen a marriage out of community of property without accrual. Meaning what? Meaning that when the marriage comes to an end, whoever believes that they're not well off financially, or they have not been working because they've been taking care of other aspects of this marriage, contributing, etc., they can go to court and ask for a redistribution, ask for the court to give them something. Now, this redistribution does not mean, right? The court, yes, agrees that the person can come forward now and ask, whether married before 1984 or after, they can come forward to ask for this redistribution. But now, it does not mean that if the court says yes, then everything is going to be split 50-50. But rather, what the judgment is saying is that the court is going to look at things on a case-by-case basis. If you bring your case forward, they will listen to you. And if they feel that, no, you've been contributing to this marriage, you cannot come out without nothing, the court can then say, no, listen, whoever's well off, give this one this amount, or give this one a certain thing. They've been here in this marriage. They've been building with you. As much as you guys decided to choose a marriage out of community of property without accrual. So it doesn't automatically mean if the courts say, okay, yes, we agree, you should get something, it's going to be 50-50. No. They might just give that person just the house, and then that will be the end of it. Now, another aspect of this judgment is this. That section that I mentioned to you, Section 7.3 of the Divorce Act, which allowed the people married prior to 1984 to ask for a redistribution, only applied to a situation where the marriage was ending by divorce, not by death. So if you lost a spouse in the form of death, and the marriage comes to an end due to death, you could not use this section. You could not say to the courts, I am asking that a redistribution be made because I have contributed here, etc. That was not available. This was also the bone of contention in this case, that it's not fair to still not allow for people to ask for this redistribution when they have lost their spouse or when the marriage comes to an end by death, because the consequences are relatively the same. Because if, for example, I don't work, I have a husband that works, and we're married out of community of property, and my husband dies, I've got nothing, because everything is in my husband's name. So I'm at his mercy. So if he has not included me in his will, I'm out. I've got nothing to claim. Maybe spousal maintenance, but other than that, I've got nothing. So the argument then of the applicants was that it's not fair. A person should also be able to ask for a redistribution even when the marriage comes to an end by death. What did the court say? The court said, yes, that's true. It should be in place. And therefore, the legislator, the person drafting legislation, must put this in place so that everything can be on an equal footing and on par with the Constitution of South Africa. So that is that judgment in a nutshell. Does that mean now that marriages out of community of property without accrual are useless? Remember, this existed for people who were married before 1984. Did it necessarily nullify those marriages? Did it render them useless? Not necessarily, eh? Because we didn't see a situation where, unless of course, because of people not talking, we don't know. But it doesn't seem like it destroyed the crux or the usefulness of a marriage out of community of property without accrual. Like I said the other time, we don't know to what extent the courts are going to make decisions when it comes to this. One thing that you just must understand is that the courts are going to look at this on a case-by-case basis. For example, there is a case where somebody who was married out of community or property without accrual and before 1984 came forward and asked for a redistribution, and it was not granted by the court. It was not granted because the court did not understand why this person was not working, why this person was not pulling their weight. Because remember, guys, some people are going to try and use these things or to manipulate situations. Another person will not want to work intentionally because they want to ask for a redistribution from your assets after the marriage. But then the courts are not as, they will use their intellect to try and see if it is a necessity for this distribution to happen. Is it just? Is it going to, equate things here? Remember also, one thing you must understand is that with all of the judgments that are being made, some of them are influenced by the fact that there needs to be a correction. There needs to be some justice, especially towards women. Because in the past, in most instances, when women were married in this type of marriage, right, they did not have any protection. Remember, the men were the ones who were working, bringing in the money. So if a marriage came to an end, the women were the ones who were disadvantaged by this. So in a sense, the judgment is influenced by the fact that they want to equate the position now of both parties who are married, so that the ones who have always been previously disadvantaged don't continue to be previously disadvantaged, in a sense. That the Constitution, it's progressive. It talks about equality. Let's try and be just towards human beings. Those who have always been favored by the law, or whatever the case is, they need to, in a sense, be put in check. So, yeah, that's the judgment in a nutshell. So like I said, if you decide to laze around and you are thinking, this judgment is going to work for me, be careful. It might not work for you, because the courts are going to look into your actions. They are going to assess why in the first place you are in a financially negative position, because sometimes some people intentionally don't want to work because they want to stay on the shoulders of others. And on top of that, they don't have much contribution in the marriage. They are just part and parcel of the marriage, but they're not pulling their weight. So in those instances, you must not think that the court is going to be on your side. The courts are going to assess this. And primary, what they want to achieve when they're doing this assessment is they want to make sure that the split and how things turn out after the divorce, it leaves a situation of justice and equitableness. So if it doesn't require a situation of correction, the courts will not give you that redistribution. So don't bet too much on it. There are people who are sitting there thinking, oh my God, don't bet too much on it. But yeah, let's end it there. But that was the decision of the Constitutional Court. So it does not mean that it's now a 50-50 thing. It's not a 50-50. But also, what I will say, like I said to another client of mine who was panicking as well about this, I said, if you're someone who's married out of community or property without accrual, and you do feel unsafe because of this judgment, you do feel somehow, you might have to look into additional measures. You might have to look into additional measures, and there's quite a few you might have to consider, so that even when your spouse tries that at the end of the marriage, whether because you have died or just you both are deciding to go your separate ways, they cannot succeed to get a redistribution that's going to be substantial. So there's so many things you can put in place so that you can feel at ease. I know a lot of people are now not feeling at ease because the situation seems as though it's opening up an opportunity for opportunists, right, to now want other people's assets that they don't want to work for. So just talk to your practitioner and then find other solutions. Make sure that you've got your things in order, right? And that way, at least you'll feel a bit comfortable. But it's going to be something interesting to see at play. And I know many are looking forward to, the law just handing down that legislation or that amendment and saying, this is where we are sitting now. These are the conditions. This is how it's going to operate. Everybody's looking at it. But it's going to be interesting to see it in practice. Like I said, obviously judges are not ignorant. They're going to assess the situations as much as they can. But also, rest assured, if at least you're someone who's been contributing in a non-financial manner in the marriage and you have been invested in it, at least you are going to have some form of protection that's afforded to you in the form of this redistribution request that you can put forward at the end of the marriage. Again, I hope you guys are not going to institute divorces just because you want to test this. It's not a good idea. It's not a good idea, I tell you. So that in a nutshell is the judgment. So I'm gonna take this video and I'm gonna post it on my YouTube video just for you to go back to it if you want to. The Legal Detour one, that Legal Detour channel, I'm gonna just put it there. You can just watch it again if you wish to. Makhatebe, one thing I can tell you is that marriage is not the issue. I always say this. I speak to a lot of people about this. The issue here we have is not marriage. It is human beings. It's human beings who others are greedy. Others want to impoverish others. It's human beings. Others are not genuine. For example, in entering into these marriages, they have sinister intentions. Others just are in the marriage just for the sake of being there, but they are not invested in. Human beings become the problem. They are the ones that just taint marriage. That's why now people are looking into the different types of marriages, because they are seeing from other people that it's just tainted. But the institution itself, beautiful. But yeah, and I think most people know that the issue is the people that they're getting married to. Some of the discussions that you listen to, you can already tell, this one can see that they're getting married to something, and there's red flags that are but they still want to enter, right? They just can't. Let me tell you, if you enter into such a situation, it's bound to come back to you. It is bound to come back to bite you, because those very red flags never go away. So once you choose a partner that's not going to be invested, that has all of these issues that you're choosing, you are going to have a problem with your marital regime, irrespective of the type of marriage you are in. Irrespective. And the reason why I say this is because I've seen people who are married in community of property, best marriage, and their planning is always joint. No problem whatsoever. And so it's not about the type of marriage. It's the people that we are getting married to. So hence, sometimes, if you are insisting on getting married to that wrong person, rather do it utilizing a different contract than the one in community of property, because you know your person. You can already tell there are things that are wrong, but you are wanting to get in. It's fine. We're not going to stand in your way, but protect some of your interests. Also, when you have children, protect their interests as well, because you entering into that situation already is an issue. And on top of that, entering into that situation with a marriage in community of property, double the issue. Because when you split up, everything goes haywire. If you die, everything goes haywire, right? So the issue, like I always say, it is human beings, unfortunately. So yeah. Yeah, man, I agree. Marriage is real. It's marriage is real. And the scam is the people we choose to marry. Those are the scams. They are the scams. Because if you stay in a marriage in community of property and you plan in accordance jointly, and the both of you are genuine, you're not going to experience problems. You're not going to. I've got clients who are married in community of property. And when they make changes to any of their plans, they come together as one. And their plans are in sync. If something happens to this one, this is what's going to happen. If this one passes away, this is what's going to happen. It's so equitable. They've done it on their own without me. They just asked me to say, just put 1, 2, 3 together. They work with each other. They don't have a problem. They're married in community of property. But now here comes you who does not align with your spouse. Your spouse does not even want to support you in planning anything, even when you're saying it's for the best of the children. They don't want to follow you. You are on your own. Do you see that it's not necessarily the marital regime? It's this person that you chose, or else it's you. Sometimes it's us. It's you. We like pointing fingers at other people, but sometimes we are the problem in the marriage. We are the red flag that was married. Let's leave it at that. The conversation was about the development and the amendment, rather, of Section 7.3. Now, if you're married out of community or property without accrual at the end of the marriage, whether by death or divorce, you can ask a court for a redistribution, meaning you can say, court, give me something from this person's estate. They have a lot. I have nothing. I've contributed, but not financially. Give me something. The court will listen to you. And if the court deems it that it's going to be equitable and just for you to get certain things, they're going to maybe give you a thing or two, or say you must get a certain amount. Then that's going to be the end of it. But again, the judgment does not say that those who have already divorced or their marriages have come to an end now can come forward or come back and say, I also divorced in that manner. Can I start asking you? You're not allowed. You cannot ask. Your situation is over, right? Yeah, that one, functus officio, it's over. It's in the past. So we're talking about now things going forward. Let me go. Like I said, I'm going to take this and just post it on the Legal Detour channel on YouTube for you if you want to watch it again. Otherwise, have a good one. Let me go. We'll see you some other time.